Good morning. This is another important case where Madhya Pradesh High Court has passed a very good order, and that was vouched by the Supreme Court. AR 2023 Supreme Court 3263. Therein, appellant who approached the Supreme Court was the Inspector of Police, received a forensic report in connection with the investigation regarding an offence punishable under Section 376. With a note that DNA exam as per guidelines be undertaken. However, DNA examination was not carried out. The accused first filed bail application. During the proceeding, the High Court called for the case diary, but the FSL report was not included therewith. The High Court issued direction to the authority to take appropriate action against the appellant for dereliction of duty. So that was challenged by the Inspector of Police. High Court could have directed the institution of separate proceeding taking recourse to Article 226 after formulating reasons and points for consideration and referred the matter to Chief Justice for placing it before approved bench to proceed accordingly. However, since the Superintendent of Police had realized that lapses had crept in the investigation and decided to initiate proceedings against the appellant, the operative post of impunity judgment became merely reiterative, perhaps in more directive, as what I had stated. As such, purely extant facts and circumstances, impunity judgment did not warrant any interpretation. This is what they say. High Court directing appropriate action to take an inspector for dereliction of duty, insubordination, and causing undue disruption in the proceedings of the court. Go through the judgment, file similar cases. Some judges must, unless and until give proper multi-number of judgments are given, directions were given from Madurai High Court as well as here by Justice Anand Venkatesan. But despite that, the police are indulging in misusing their power and behaving like unruly elements. Calling a poor lady to a police station just simply says one Jawahar has given complaint against. What complaint? Nothing. When directed her to appear before the Deputy Commissioner of Police. When she went there, Deputy Commissioner of Police official says, no, you need not come, you go to H3 police station. When she gone to H3 police station, the inspector says, no, you ask some sub-inspector of police to inquire. What is this happening? And sub-inspector of police wants all the relevant records. Tenancy of ACP is rent control authority. All nonsenses are prevailing and they are disobeying the order. These judgments should be like judgments like these cases should be. See, that the problem is, how can I ask that poor lady to take action against the inspector or the whatever it may be by correspondence or by approaching Women Rights Commission, approaching High Court and 482, wasting money. Poor girl not able to drive her wolf out of the door. How can I charge this? This is nothing but inhuman, barbaric act of police officials. And the higher officials have no patience to look into the complaint or depute some subordinate official to look into the complaint, whether the complaint is civil in nature or crime is imputed in the petition. What is it? Current petition, currency petition, current petition. All nonsense. Best wishes.